People are in. Okay, we'll go ahead and get started, everybody. Thanks for joining us today. Uh, Before I really get started, I just had some housekeeping things that I wanted to hit on real quick. Make sure in order to get your CEU, we need your full name. So if your full name is not showing up, please just put it in the chat, just so Kirsty and everybody over at the central office can get you your CEUs. The CEUs should be ready within a week, or a couple of weeks. Almost made Kissy's job harder. Uh, a couple of weeks. Certificates and CEUs. November 17th, you should start seeing registration for the conference, the annual conference up in Traverse City, November 17th. And aside from that, that's pretty much all I have as far as housekeeping things go. So, again, thank you everybody for being here. This is our third lunch and learn for the year. This is kind of our inaugural year, our first year. Can't say the word. Our first year of doing this, and it's been a great success. So thank you everybody who's participated and been involved. So with that, I'm going to go ahead and introduce our speaker today. Rick Linnell with Linnell and Associates has been gracious enough to speak today on riparian rights. And as this goes on, I'm sure Rick will second me here, but if there's any questions, feel free to just speak up. Just feel free to interrupt him. And if there's a topic within riparian rights or whatever that you'd like Rick to maybe hit on, let him know. I'm sure he'd be happy to discuss it. So I'm gonna stop jabbing. I'm gonna stop talking here, Rick, and give it away to you.
Great. Good morning, everyone. Just to echo what Joel said, I really appreciate questions. That does not mean I will know the answer to the question, but I will do my best and, of course, be honest about what I do and don't know. Um, as far as the presentation, so I've taught this presentation previously, but I've never taught it to surveyors. I am not a surveyor. And the point being that if I'm talking about something that's not interesting, not germane to surveyors, I have no problem if people prompt me along, or if they want to prompt me along by saying, "Hey, Rick, can you talk about this? Can you touch on that?" I would love that because if one person thinks that, of course, it's most likely that a couple other people, if not everyone, is thinking what Rick is talking about is not very interesting and not very relevant to us as surveyors. So I'm being very sincere when I say that. I know some of the people in the room, many I do not, but for those of you who know me, you know I'm being sincere when I say, please feel free to prompt me. So, with that said, oh, why is this not? Try and change the slide here. Is my screen sharing?
Yep, the screen is sharing.
You can't get
I'm
the
seeing
slide
it.
to move. Oh, there it goes. Great. Perfect. Okay, so my quick background. I have been in real estate since 1996. I started working for a real estate developer while I was in law school, local developer in Bloomfield Hills. And I was fascinated by real estate. I don't have anyone in my family that is involved in real estate in any way, but as soon as I got a chance to be involved, I thought this was the greatest thing that I'd ever been a part of. And luckily, the gentleman that I worked for kept me on after being a summer associate between my first and second year law school. And after I passed the bar, I stayed with them until late 2008 when things got unpleasant for them. Actually, they got unpleasant for me too. So while I worked for these gentlemen, and they worked on all kinds of property types, childcare, assisted living, light industrial, retail, a little heavy industrial, residential, manufactured home communities, stacked condos, attached condos, site condos, platted subs. And they did it in 5 states, mostly Michigan, but also Ohio, North Carolina, Georgia, and Florida. And while I worked for them, I did a lot of the property acquisition work, knocking on the farmer's door or finding the property owner and trying to get them to sell or doing assemblages. I would also write the contracts for acquisition. I would do all the presentation work before municipalities to try and obtain site plan approval or a PUD or a PRD, excuse me, special land use, conditional land use, variance, etc. And while I worked for them, I was able to develop a little over 900 lots working for them on various projects. And if I brought a project and it was didn't meet their floor, they had a certain deal size, which I thought was still pretty large, then I was allowed to do that myself, although I needed partners with money. And so for myself, I developed 146 lots over various subdivisions, all in the greater Detroit area. As I said, I stopped working there in 2008 because, well, unfortunately, times got rough. And they also got rough for me. When times got rough, I started dealing with the distressed market, which I was a part of. Unfortunately, I owed the bank many, many multiples of what I actually had. And I was able to get my way out of it and help some other people get out of it. And as the market got better, I returned to traditional real estate, non-distressed real estate, or at least not all distressed real estate. My practice, of which I am the owner, but I do have 7 other attorneys that work for me, everybody is focused on real estate, both litigation and transactional, except for one attorney who does probate and estate planning. And that oftentimes finds itself delving into real estate. So, with that said, let's move forward with the presentation. So, we are going to be talking about riparian rights. Those are the rights that are associated with the ownership of property that abuts a river, a natural river, or inland lake or stream. Uh, Pardon me. I'm going to be talking about statutes. I'm going to talk about case law. But again, I know I'm repeating myself, but I want to be clear. If people have questions, they should absolutely pipe in. Uh, in Michigan, oh, why is this not prompting? Sorry. In Michigan, we actually have 2 terms that you might see, depending on what you're looking at, for what is often collectively referred to as riparian rights. Riparian rights actually, or riparian refers to land that abuts a river. Littoral is a term used for property that abuts a lake. Now, I say abuts. If it abuts or actually goes into, in other words, there's bottomlands, it's also riparian or littoral. But the minimum threshold is that it abuts a river or a stream or lake. Michigan courts at this point, and it's been going on for decades, use the term riparian even when discussing rights associated with a property that abuts a natural lake. So there is no need to use the term littoral unless it comes up, but I just bring it up in case that in case somebody runs across that term. But it's really not used at all. There are 2 classes of riparian, and I'm going to use riparian going forward exclusively. But again, I mean riparian to incorporate littoral rights, so any natural body of water. Um, there is 2 classes of use. One is natural. The natural use is what is the minimum needed by a riparian owner to sustain themselves. That's almost a direct quote from the language. And for example, as drinking water. Then we have artificial use, and artificial use would incorporate any kind of commercial activity, a marina, would incorporate recreation, boating, etc. It's important to touch on the various bodies of water in our state. As we all know, we're very blessed in our state to have untold amounts of water, fresh water, which I'm a fan of, over oceans, that is. First of all, we have Great Lakes. So riparian rights with respect to the Great Lakes is based on property that abuts the ordinary high water mark. So now I've changed, not changed, but I've expanded the term. So earlier I was saying abuts a body of water. Well, as many of us might know, bodies of water, they're sort of a living thing, if you will. They rise, they lower, And at least to some degree, generally speaking, they're in some state of flux. And so the determination as abuts a body of water, well, theoretically, a parcel could abut a body of water today, but might not abut it tomorrow, depending on the water's movement. And so the actual definition, when somebody says, well, does it abut a body of water? The question is, does it abut the ordinary high water mark? And we have different standards depending on which body of water we are actually talking about. So, with respect to the Great Lakes, the ordinary high water mark is established, and it can be found under, and I'm going to go to the next page in a second, but it's actually easy to Google. It's kept an international datum of what each Great Lake is on a year in and year out basis. With respect to inland lakes, the ordinary high water mark also applies. But that is something that you typically can find from your local drain commissioner. With respect to ponds, ponds do not offer riparian rights. Now, I oftentimes get the question, they say, well, Rick, what's a pond and what's a lake? And so, as an example, as a kid, I was very fortunate. I grew up on a lake. Um, I thought it was a lake until I got a little older, and then I had people refer to it as a big pond. Um, and so it is a little bit of a term of art. I would tell you that I distinguish pond from inland lake by size and location. Specifically, I would define a pond as anything under 5 acres that is not a part of a watershed. And the reason I use that definition is that is the definition for Energy, Great Lakes, and Environment, EGLE, which is one of the state offices. It's the predecessor to the Michigan Department of Environmental Quality. And that is the threshold for regulation. And so to me, that is a good definition to use. I can't tell you that there wouldn't be an exception to the rule, but I think that's a good definition to use. And again, a pond would be, generally speaking, would not have riparian rights associated with it. And I use, again, you heard my definition. All right. So the ordinary high water mark. There are two different ordinary high water marks that are used. There is the established high water mark, and there is the natural high water mark, and they can be different. Maybe that's obvious. They could be different. Why? Well, because nature moves. It is not a constant. It ebbs and flows, like the common quote. Whereas the established high water mark, and we'll use the Great Lakes as an example, is maintained at the International Great Lakes Datum, which is part of EGLE. And so it's established every year. But again, water is moving. One thing to note about the Great Lakes is that ownership extends to the ordinary high water mark. And I mentioned earlier that it is possible. In fact, I would tell you quite likely if a property is riparian in nature and it's on an inland lake, it's quite likely that the property extends into the lake. In other words, that there are bottomlands that are included as part of that parcel. Whereas with the Great Lakes, the property abuts, generally just abuts the ordinary high water mark. And one thing that's important about the Great Lakes to know is that any property below the ordinary high water mark, which, by the way, may be upland. In fact, oftentimes it's upland because the natural high water mark and the established high water mark are oftentimes different because of the movement of water. But there's something called the public trust doctrine, and it allows everyone in Michigan to use the property that is at the ordinary high water mark or below. In other words, that's the line. So people get to freely walk along the beach. People get to fish on the beach. There is no ability, despite many efforts to do so, by private landowners who are riparian in nature. There's no ability to prevent the use that is afforded every citizen in the state of Michigan, and for that matter, visitors, as part of the public trust doctrine. With respect to inland lakes, and I will tell you that much of my practice with riparian rights focuses on inland lakes because, well, that's where most of my work comes from. And that seems to be where much of the fighting, maybe not fighting, but disputes take place. With respect to inland lakes, I think I said this earlier, but the ordinary high water mark is usually there's a record maintained at the county drain commissioner's office for establishing if, in fact, you are sorry, not establishing if you are, but establishing the high water mark, and then the property, which we'll touch on, does it abut the high water mark or does it extend into the water, in which case, of course, then it definitely touches the high water mark. Riparian rights versus water law. So again, this is focused on riparian rights, but I do want to touch on the difference between riparian rights and water law. Riparian rights deals with the rights to use surface water. Water law deals with subsurface, not subsurface, but below ground water. And they're distinguishable by that. Again, we're going to stick to the riparian rights and the surface water. So, next slide. I did want to touch on, I've said natural more than a few times. If a property abuts an artificial body of water, in Michigan we have quite a few. Oftentimes it's a dammed up river that creates it. If it is an artificial body of water, even if the property abuts the high water mark, that does not mean that the property is riparian in nature. The right to use the water is going to be governed by the documents that created the property, typically a plat. And as to the level of use, again, of the water, if any, is governed by the plat. What I would say, though, is that it would be a very unusual situation. In fact, I don't believe I've run across it, where a property abuts an artificial body of water and that property is not afforded at least some, if not all, of the typical rights associated with riparian use. So I would want to be clear, riparian rights only stem from a property abutting a natural body of water, stream, lake, etc. But I have yet to run across an instance in which an artificial body of water abuts a property and that property does not have riparian rights as well. But that would be something that a purchaser should investigate if they are looking at riparian land. Most of the case law is under common law. There are three main doctrines that govern riparian rights: the natural flow, reasonable use, and appropriation or prior use. I would tell you that most of the focus in riparian rights is on reasonable use, which is every riparian owner has an equal right to use the body of water. But for instance, that does not mean that a riparian owner could divert water to crops, for instance, that, so they own a 100-foot lakefront property and they divert water, hundreds, thousands of gallons to some farm property because they have the riparian rights. No, it's the reasonable use doctrine, which generally follows logic, limits the use, but the use cannot be to the detriment of the other riparian owners. I realize that's probably a little bit of a loaded word. What is detrimental? What is not detrimental? I would tell you as a general rule, normal recreation. So you're not, doing anything that pollutes the lake. You're not doing anything that disturbs the ecosystem. You're not manipulating the shoreline in any significant way. You're not divesting water from the lake in any significant level. And we're not talking about you're irrigating your own yard. That's really what the reasonable use doctrine looks at and governs. Natural flow and repair and reasonable use are doctrines that are both respected and are used as guiding principles in Michigan. Appropriation or prior use is not necessarily followed by Michigan law, which it's, I mean, in Michigan, I think part of it is that we're quite fortunate with all the water. We don't have quite the issues that they have out west, where they have limited water and appropriation of water is a big issue, especially where many of the rivers flow from state to state to state, and those states that are earlier in the flow, there's concern about them using and what's left afterwards, etc. All right. I talked a little bit about riparian uses or reasonable use, excuse me. So now I want to talk about types of riparian rights. First, we have use of the water for domestic purposes. To be honest, I think that most of my cases, most of the case law that you see deals with B, the recreational use of water. This is what most people are focused on, the ability to install a dock, the ability to moor a boat, the ability to swim, fish, sunbathe, and picnic. And these are all riparian rights. The most valuable probably are obvious, and it's the ability to install a dock, and it's the ability to moor a boat, more specifically, the ability to moor a boat overnight. That is what generates, I don't want to say all the value of a riparian property because the aesthetics are there to view it, but much of the value is derived by the ability to install a dock or to moor a boat overnight. One of the things, and I've got some cases. I tried to pick ones that I think might have some interest, which we'll get to. And that is, at some point, I want to make sure I talk about bottomlands. I think that that's an important issue that we talk about, as well as issues regarding the ebb and flow of land. So I've said at least once, maybe twice already, that it is typical on an inland lake that an owner's property, or not an owner's property, but a property would extend into the water. And this is a very common scenario, but it is not always the case. The case law says that unless there is a clear, and I'm paraphrasing, but I've looked at it enough. I might not be able to quote it, but I'm telling you, I'm giving you the right definition. The case law says that unless there is a clear intent for some other ownership or for a property to not have riparian rights, the fact that it abuts a body of water, specifically a natural body, although I don't really think the clarification is necessary from a practical aspect, it is deemed riparian in nature. I bring it up because there's a couple things that happen. As the ordinary high water mark moves, a property that was riparian might no longer be riparian. And one of the principles, if you will, that is used or is a part of if that issue arises, which it does all the time, is something called accretion. And accretion is the natural receding of water or creation of additional upland that didn't exist. The counterpart, although it's not exactly a direct counterpart, but sort of the counterpart, if you will, which is instead of the increase in upland, the decrease in upland is avulsion. And generally speaking, and it's case by case, but I do think generally speaking is a fair way to state it, and that is that if you are the owner of property that abuts the ordinary high water mark, and then accretion occurs, which means the lake recedes, generally speaking, the accreted land becomes or is incorporated into, at least from a legal standpoint, and becomes part of the land that formerly abutted the high water mark. In other words, the landowner gains more upland and retains its riparian status. Conversely, in avulsion, the same is true, although obviously if the ordinary high water mark increases, it stands to reason that the property would retain, its riparian rights. Um, the a lot of the issues that come about deal with bottomlands and the ability to use one's bottomlands. And I just talked about accretion, which is, of course, if there's more upland, not of course, but if there's more upland, it is the general legal principle is that that land becomes part of the existing upland that was riparian nature. But I'd also want to touch on bottomlands. Um, Many, as I've said, many lakes have where what I'm going to refer to as they pie out, or people of my age might remember the video game Tempest. And that's essentially what happens with the bottomlands, where the, the, the upland, as it moves to the bottomland, pies to the center, which is often referred to as the thread of the lake. I've seen many different configurations where there's been a line drawn in the middle of the lake on a plat, and the lots continue in width out to the middle of the lake, and then some pie out. I don't know what was happening. These plats are generally before my time, many, many decades before my time. But the general rule is that if you are riparian in nature, you have the right to install a dock, even if you do not own the bottomlands. Um, Bottomland ownership is essentially no different than upland ownership, although your rights with respect to bottomland are tempered by the right of all riparian owners to use the surface water, and if there's any access to the lake, for the public at large to use the surface water. In other words, you may own the center of the lake. You cannot install a structure that is in navigable water. Navigable water is generally anything 4 feet or deeper. And so even though you say, well, I own the bottomlands, I want to install, something 300 feet offshore where it's 20 feet deep. You do not have the right to do it despite the fact that you actually own the bottomlands. Conversely, as a riparian owner who owns bottomlands, you do not have the right to prevent the public at large from temporarily mooring to your bottomlands. What is temporary? From sunup to midnight. So someone can show up, literally an inch off your shoreline, anchor and fish all day until midnight, and they have every right to do that. Now, that right is tempered by the fact that anyone who is temporarily mooring a boat may not prevent or hinder the riparian owner's right to access navigable water. In other words, they can't block you from using your property in your riparian capacity. And someone says, well, Rick, I have a bunch of kids over swimming and there's a boat there and they can't use that swim area. They can only use this part of the swim area. And I would tell you as a general rule, the non-riparian owner, the temporary moorer of a boat, has that right. Um, the biggest questions that we get from owners of property is, may I install a dock and do I need a permit for a dock? Uh, First of all, any permitting would be through Eagle, Energy, Great Lakes, and Environment. Now, I say that, I would want to be clear. If the property is on the Great Lakes, then it's the U.S. Army Corps of Engineers. There are many applications like Lake St. Clair, for instance, where there is joint permitting through Eagle and U.S. Army Corps of Engineers. But those are the governing bodies for permitting, and I say for docks because that's what I'm mentioning, for seawalls or permanent docks or other types of structures or improvements that might be made at a water's edge or even into some portion of the bottomlands. The answer to the question that I pose is If you are a riparian owner, you are permitted to install a dock, period. Now, when I say permitted, maybe I should use the word allowed. You are allowed to install a dock. That is a riparian right. The next question is, do I need a permit for my dock? And what I would tell a property owner is if your property is single family by zoning, and if your property is improved to where it has a single family home, and if that property is used as a single family home, which doesn't mean you have to live there, but it could be a vacation home, and the dock is seasonal, a permit is not required. If you change any of those facts, a permit may in fact be required. Um, the permit would come from, again, from Eagle if it's an inland lake. Does that mean if you change the facts you have to get a permit? No, but I'd have to know the facts before I could answer the question. Um, Permanent docks, boathouses, which is on an inland lake is essentially impossible to get unless there's an existing one. They require permitting. If there's more than one single family using a dock, if it's not seasonal, if it's permanent, if it's a marina, which for the average person, when they hear marina, they're thinking 100 boat slips, some kind of serious commercial operation. To be clear, a marina permit, I've seen them requested for associations many, many times. A lot of the litigation that we see has to do with a community lot, a park lot, if you will, for a particular platted sub, or it could be a site condominium or a traditional condominium. And what are the limitations of use? And one of those issues is oftentimes, am I permitted to have a dock? Am I permitted to have multiple boats there? Are the boats permitted to be moored overnight? And Eagle, if you call them, will tell you in that scenario. So it's a lakefront park. It's a modest usage. There's 6 boats and a seasonal dock. Eagle will tell you that that requires a permit, in my experience. Now, what I would tell you also is that generally speaking, Eagle, and this is just my personal experience, is what I would call understaffed. Now, I don't know if they would use that term, but I would say understaffed. And I say that because, generally speaking, Eagle is not looking to regulate that scenario I just provided with the 6 boats in a seasonal dock. I'm not telling you that they won't regulate it, but in my experience, they have more significant issues that they invest their resources in. What sort of scenario would cause a Eagle to participate or to take notice of a particular association dock, like in my example? One might be the municipality contacting them. Individual lakefront owners, I'm not going to tell you that the complaint would fall on deaf ears. I have nothing negative to say about Eagle at all. I work with them frequently. But from a resources standpoint, when I see a municipality contact them, they they seem to take more of an interest, although I'm aware of firsthand instances in which Eagle did not make a regulatory effort, despite the fact that a municipality had contacted them about a dock at a communal property with boats that were owned by different people. The question then is, may I moor a boat? And if you are a riparian owner, you are absolutely allowed to put a dock in, given the factors I've already talked about. Are you allowed to moor a boat? Absolutely. And the real question is, may I moor a boat overnight? And the answer is yes. Your boat, you own the property, you have a single family home, you use it as a single family home, which just means you're not using it for commercial purposes. And when I say commercial purposes, I'm not referring to short-term rentals. I'm talking about, hey, I have a dock on a lake and I'll charge you $5,000 and you can leave your boat there for the summer and I've got 3 slips available. And that would be the kind of commercial activity that I am referring to. Um, Aspects that are of consideration for the level of use that is permitted on a particular piece of property. Give me a second here. Get my slide. Hmm. There it goes. So limitations, restrictions, and responsibilities. These are the areas that a riparian owner or a potential riparian owner should consider. One is Eagle. I would investigate to see if there's been any prior action taken with the site. It could be a permit, could be an investigation, could be alleged violation. I'd want to know, even on a single family residential property. It's likely there hasn't been any action, that there is no file, but I would want to know that in advance. I can think of an example I have right now. I have an appeal to a health department in northern Michigan because they have denied an engineered field for septic for multiple lots that my client owns. And one of the issues, in fact, probably the main issue, is a claim that fill dirt was put on the site. And this is a riparian property, or properties, plural. Um, the the record keeping, it's so old that I don't believe that the fill would have ever been reasonably ascertained or identified as existing. Um, so I'm not, so in this particular instance, it's not applicable, but fill dirt, um, which is oftentimes governed by Eagle if it abuts water, and or illegally installing a beach or illegally removing wetland plants, soils, etc. There'll be a record of it at Eagle, and if there is no record, then I would take comfort in knowing that the property is in fact conforming or appears to at least be conforming based on Eagle. I would also look at local municipalities. Oftentimes you'll see that they will have regulations that govern bodies of water. This is not always the case, but we definitely see it from time to time in municipalities. So I would review the zoning ordinances and regulatory ordinances. Typically, one would only look at zoning ordinances because that governs the use of land. But I have had a couple instances. In fact, I had a lawsuit that we may talk about today, with a city that was trying to claim that what read like a zoning ordinance was in fact a regulatory ordinance. And why that is significant. A zoning ordinance governs the use of land. A regulatory ordinance governs the general activities of the public at large and what they're permitted to do, falling under the health, safety, and welfare, which is the touchstone words that all municipalities use. Why? What's the difference? You know, if they read the same way, why? Who cares about zoning versus regulatory? It's an ordinance. It's an ordinance. Well, it is significant, or can be significant, because you may have heard of the term grandfathering, which is the term I often hear. Grandfathering really translates to a pre-existing non-conforming use. Simply speaking, you were doing something you were permitted to do. An ordinance was adopted that said you can't do this something anymore. However, because you were doing it before the ordinance was adopted that says you can't do it, and you continue to do it, you get to continue doing it in perpetuity, forever. That is a defense to a zoning ordinance. So, in that particular case, there was a park, there was a dock put out, there were many boats on the dock, and the municipality said, "Well, you can't do that. You got to get rid of the dock and all the boats." And the ordinance that they cited was from 1987. It just so happens that in the case, we were able to establish that a dock had been there. Again, I don't have daily photos, and I couldn't even get yearly photos, but I had photos going back to the late 30s from the Detroit Historical Library, and I had some from the 40s and the 50s, etc. And I could show that a dock had previously been there, and I could also show that boats had been there. Now, just to be clear, I don't want to be confusing. The use has to be from 1986 in my case. Why? Because the ordinance was adopted in 87. Now, I had historical use much beyond that, but I only had to show that there was use in 86 and that it continued. And if I could show that this pre-existing use was in fact in place and maintained, then that is a defense that my clients or I had to prove on their behalf. But if I could prove that it was existing and continuous, then that is an absolute defense to a zoning ordinance that says you can't do that. Well, in this particular instance, the municipality argued it was a regulatory ordinance. Again, what is the significance? The significance is that a regulatory ordinance is enforceable regardless of any pre-existing non-conforming use. So even if you can establish my grandfather did it, then my dad did it, I'm now doing it. This regulatory ordinance was adopted in 2004. Our use predates that ordinance by 50 years. I'm making an example up, of course. The courts would say, we got it, we hear you. It doesn't mean anything. You are no longer permitted to engage in this pre-existing non-conforming use. And oftentimes these pre-existing non-conforming uses are the basis for maintaining some particular use, oftentimes a valuable use. And this doesn't have to be riparian. I've had it in all kinds of applications, but it does find its way into many riparian matters. Next, deed restrictions. Any restrictions contained in the deed itself as to the use of the property, limitations on dock, amount of docks, dock length, amount of boats, boats have to be registered to the owner, etc. Next, subdivision restrictions, otherwise known as covenants, conditions, and restrictions, or master deeds. It just depends on how your particular property was created as to whether this applies. Obviously, there are properties that were not part of the subdivision plat or were not part of a condo splitting a property. But look in those restrictions. There may be language that governs the use. One of the challenging parts about plats, which much of the lakefront seems to be platted, because even back then they realized it was valuable before the Condo Act was used or even created. The plats, because oftentimes they are so old. In fact, I'm going to trial on a plat from 1877, I believe. They didn't write like we write now. I mean, they're using the same language, but they just didn't think the way we think, and they didn't write the way we write, and they didn't have the issues or concerns that we have now. And so it can definitely be tricky sometimes to determine what rights do or do not exist when reviewing a plat. But that's what I look at. And the last thing, which I don't have up here, is a lake board. Not all lakes have lake boards. In fact, it's somewhat uncommon, but a lake board may govern hours of usage, horsepower, oftentimes weed removal. And so I would look to see if there's any impact that would be of concern to a riparian owner. Going to bottomlands, and I want to go to a specific case. By the way, if I haven't heard any questions, I was thinking I might get some questions. I hope that doesn't mean I'm boring you. So if you have questions, please fire away.
Not boring at all, Rick.
Okay, good. Well, if you have questions, it's going to make it more exciting. Okay, so this is a case that I had on White Lake within the last 10 years. It was two residential property owners, and it was probably about 10 years ago now that I'm thinking about it. The properties were side by side. They were old platted lots, and they were like a bowling lane, if you will. They were 40 feet wide by about 230 feet deep, which is not unusual for lakefront lots because, well, like I said, as we all know, the people used to have a 500 square foot cabin, and now they have a 4,500 square foot house on the same lot. And this one was slightly interesting in that the lot lines came to the water's edge, and I should, by the way, I should make sure I touch on this. So, one of the concerns, which I've touched on a little bit about the high water mark receding, and this only applies if the property does not extend into the bottomlands. If a plat says that the property extends to the water's edge, it's riparian, even when the water's edge moves. So if and unfortunately not enough plats say that. There are many plats that don't have that language. But if the plat says it, it makes it crystal clear. The courts recognize it. The property is riparian in nature, even if the ordinary high water mark moves. That was not the issue in this particular matter. In this particular matter, the lot lines, when they got to the water's edge, so I'm sure all of us, or at least most of us, have been to a lakefront property or seen it, observed it. What you typically see is that a homeowner or property owner will place their dock perpendicular to the shoreline. Now, the shoreline undulates, as you can see in my picture, and White Lake is on the right. Dunham, no, not Dunham Lake, Duck Lake is on the left, by the way. We're talking about the lake on the right. Uh, is to set your dock in the middle, set it perpendicular, and that makes for friendly neighbors. That is the recommendation of Eagle. It is not the law, although some municipalities do have it as a rule, a zoning ordinance. When the property lines got to the water's edge, the lot lines went off at a 45-degree angle. So if the lot lines are like this, one would expect them to project in the lake like this. But instead, it got to the water's edge and literally went like that. And quite honestly, I don't think anyone knew about it. My client didn't really know about it. The neighbor who we had the lawsuit with didn't know anything about it. I don't think, at least not at inception, not when they purchased, because like most people, you looked, you said, okay, does my property touch the water? Looks like it does. Um, that's good enough for
Hey,
me.
hey Rick. Hey
Yeah.
Rick. I know you're not probably looking at the chat, but there's a couple questions. I got one that says, thoughts on use of lake at road ends.
Ah, I'll switch gears and I'll come back to this if we have time.
Yeah.
So there's a case, pardon me, there's a case on Higgins Lake that governs the use of public road ends. The case decided, and it was a blow to many people who had traditionally used road ends as their access point for water and placed docks and moored boats overnight. And it effectively terminated it. The high points of that case said that the public at large, so anyone in the state of Michigan and anyone visiting, has the right to use a road end, a public road end. I want to be clear, and I'll come back to private road ends if I don't prompt me, but we're talking about public road ends. The public has the right to use the road end for ingress, egress into the lake, to get in, to get out. The public is permitted to fish from the road end. The public is permitted to carry a kayak, a stand-up paddleboard, a canoe into the water. The public is free to swim and frolic in the water at the road end. The public is permitted to sunbathe and picnic at the road end. The public is not permitted to install a dock. The public is not permitted to moor a boat overnight. Can a boat be launched? I said carry a boat. I would want to make sure I'm clear. A boat could be launched. So the ground is sufficient. You have your car, you got your trailer, your boat's on your trailer, you back up, you launch your boat. No problem. Totally permitted to do that. Can you temporarily moor your boat? Yes, like we talked about, from sun up to midnight. You can absolutely temporarily moor your boat. You cannot moor your boat overnight, period. It's a $500 fine each night if you're cited. Can you install a dock as a member of the public? You cannot. The local municipality, whoever has rights to the road, they may install a dock for use by the public. You may temporarily moor your boat to that dock, so you you're on the lake, you come off and you want to get some more sunscreen or some food or water or whatever, sure, you can do that. It's not there for you to leave it all day. Now, is anyone monitoring it? I don't know. You'd have to tell me where it is, but um, that is the limitation on the use of a road end. I would want to be clear that any right to sunbathe, picnic, fish, moor a boat temporarily, all rights you have, by the way, I want to be clear that you, being the general public, those rights are tempered against prohibiting or impacting others' rights to use the public road. In other words, if you moor your boat and someone can't launch their boat, you can't do that. You are laying down on the ground sunbathing and someone says, well, I want to drive where you are so I can launch a boat. And you say, nope, I got to get this tan going. That is not permissible. So that governs those rights. Now, switching to a private road end. Private road end is governed by whomever has the rights to the road. So let's say it's a road end as part of a plat. Generally speaking, the platted roads are for the benefit of all co-owners. So that means that all co-owners could use the road end. But there's more analysis to be done, which is what was the intent of the grantors regarding the road ends? In other words, were those road ends intended to be used for riparian purposes, like to install a dock, to moor boats overnight? And you would need to look at the plat itself. In Michigan, if an easement, which is how plats are viewed, if an easement is clear on its face and it's not susceptible to more than one reading, in other words, two people read it, they're going to come up with the same idea of what you can and can't do. If it's clear on its face, that is the end of the investigation. And someone says, well, no, Rick, we have had a dock there for X years. Rick, we've been mooring our boat. In fact, the boat we bought from the people before us who had been doing it X years before them. Does not matter. The courts strictly interpret easements as written if they are clear on its face. If an easement is not clear on its face, it's ambiguous. What is ambiguous? Meaning it's susceptible to more than one interpretation if two different people read it. If an easement, and this is not just about riparian rights, this is any easement. If an easement is ambiguous, then a court may consider any extrinsic evidence put before it. What is extrinsic evidence? Any evidence you have outside of the four corners of the document that would assist the court in trying to determine what was the intent of the grantors when the plat was created. In other words, the people that created what it was the intent of this, in our example, this private road end. Well, what extrinsic evidence? Well, the best extrinsic evidence would be any evidence that's contemporaneous with the plat being created. That's pretty darn hard to get because, as I've already said, most of these plats are very old. In fact, it would be unusual that there was anyone even alive when a lot of these plats were created, or certainly someone that had memories of what was happening when the plat was created. And so oftentimes you are left with presenting evidence that's historical, but may not have been contemporaneous with when the plat was created. I have a case, and when I say I should be clear, there are many people in my office who do a lot of great work. One that I would like to highlight is Hunter Avis. Hunter Avis, I believe, is in the top 5 riparian attorneys in the state. I'm fortunate to have him work with me / for me for the last 12 years. And he and I do things together on most of the riparian cases.
Hey, hey, Rick, real
Yes.
quick, just wanted to give you a time check here. I know we just want to give you a heads up.
Okay. So what we had a case where the Court of Appeals, because we lost and we appealed it and the Court of Appeals sided with us. We actually went there twice and won both times. But the Court of Appeals, it's a case Kraus v. Link that we argued, and it states that a court may permit or may consider, any extrinsic evidence presented to it, and it may put weight on it. So, for instance, a picture from today regarding a plat from 1930, the court says, yep, I see what you're presenting, and the probative value is zero. Whereas an aerial picture from 1950 from the Detroit Historical Museum or Library, excuse me, might have a much greater weight. The court decides, but the important part of that decision is that if you don't have contemporaneous evidence, it does not mean that you can't establish what the intent of the grantors was at the time that the plat was created. Are there more questions in the plat or in the chat room? Sorry.
Yeah, Rick, let me so there's actually two of them here. So one of them one says, can you gain prescriptive rights for the use of the lake? That's the first question. And then there's one other question after that I got here.
All right. Can you gain prescriptive rights? You can. A prescriptive easement is adverse possession without the exclusive component. So adverse possession has multiple elements to it. You have to prove each one: open, notorious, hostile, exclusive, continuous, etc. And you have to do it for 15 years. You can absolutely establish a prescriptive easement. The one thing that I would add, and of course I don't know if the person that asked the question, if this is a particular scenario, is we see that question asked often, and it's around the fact pattern where I am a member of a community. We have a lakefront park. It doesn't say I can have a dock, but I've been putting a dock in there, and I've been mooring a boat overnight, and I've been doing it for over 15 years. I believe I have established a prescriptive easement claim, and it's all fact driven. But generally speaking, I would tell you that the co-owner has not established a prescriptive easement claim. And the reason is that use has to be hostile, adverse. That's really what it is. Well, the courts generally find that adverse possession or prescriptive easement, they're the same except for the exclusivity component, cannot be established if you have a right to use. In other words, if you're a co-owner and you have a right to use a park, and your argument really is, I'm overusing the park, generally speaking, the courts will say you cannot meet the adverse element. Why? Because you have a right to use. How are the other co-owners supposed to know when you're using it consistent with the rights that you have as a co-owner versus exceeding those rights and you're making an adverse possession claim or prescriptive easement claim? I am aware of some cases where that principle does not apply. I can think of one on Watkins Lake where there was a boathouse on a community park lot, and the boathouse was, as you might imagine, quite substantial. It had been there for over 50 years. And in that particular case, the court found that the level of use exceeded what was permitted by so much that any other co-owner would have realized that the use was adverse and could have made a claim or attempted to discontinue the use. And because they didn't do so, a prescriptive easement, or in that particular claim, adverse possession, was in fact established. All right, how about another question?
Yeah, so the other one, next question I got is, there is a platted undeveloped road along Higgins Lake. It allows for people to use the beach. It also allows for backlot owners abutting the road to install a dock. How are they allowed to install a dock and prevent anyone from walking on it or using it?
Well, so the question states that the use of the unplatted road is being prevented.
Yeah, and Rick, you should be able to see this too.
I know I should, but I don't know where chat is. I'm looking
So
for
go
it.
to the bottom. There should be on the kind of a bottom ribbon, I think, where it says chat.
Hmm. I apologize, but I'm not.
That's all right.
I'm used to seeing it, but I don't see it. So, um, the so I just want to make sure I understand the fact pattern. The road is there, but the use of the road is being blockaded by those property owners that abut the road on the non-lake side. In other words, they're using it as though the road is theirs and putting in docks and preventing the use of the road itself. Is that correct?
That's what it looks like. Yeah. How are they allowed to install a dock and prevent anyone from walking on or using it?
Okay, well, if the person wants to unmute themselves, I'd be happy to hear more, but I'll start answering. So My first question is a public or private road? I think you said public, but I may have been inserting facts.
Undeveloped, it
It's
says there's a plat. Sorry.
it's a public road that was platted, but it's undeveloped. There's no road there. It's along Kelly Beach, if you know that area.
Okay.
Um, and they allow everybody to use the beach area to you can sunbathe, you can do anything you want, picnic, but the the people that live on the other side of the road, on the side opposite the lake, are allowed to put docks out there and prevent anyone from using the docks, walking on it, or doing anything else on it. But you can use the remainder part of the beach. So I was wondering how they were allowed to tell you you can't walk on their dock or use their dock.
Well, I would want to know more, but I'm happy to give my answer based on what I've heard so far. So, if a property abuts a road that runs along a water's edge, the general presumption, which there are many times it's not true, but the general presumption is that that property is riparian. In other words, the fact that the road's there does not mean the road between themselves and the water's edge does not mean that the property is not riparian. In other words, generally speaking, it is riparian. There can be facts brought up. Things I'm not saying it's always the case, but that's the general presumption. But what is unusual is that just because that may be true, which I suspect it is, but I don't know that, does not mean that the general public would be or legally could be prevented or blocked from using the road. In other words, they could walk along the water's edge and the road. That doesn't mean that the abutting homeowner on the other side of the road couldn't put their dock in. They couldn't. They should not be able to put it in to the extent that it prevents um, pedestrian use of the what I'm going to call a paper road, which is what it sounds like. I have seen, and you were clear, so I don't think this is the same, but I have seen on many lakes what's referred to as a promenade. That must have been a thing back in the 20s, 30s, etc. And there would be a promenade along the water's edge, and people don't use promenades anymore. I can think of Wolverine Lake. There's a Long Lake, which I know there's probably 50 Long Lakes in Michigan, up near Oscoda, Cass Lake, and they'll have these promenades that are not used. But the fact that the promenade is not used, it's like a paper road. It's a paper promenade. That doesn't mean it disappeared unless there's an attempt to vacate and abandon it. It's still there. So I'm happy to hear more about this because from the facts I've heard, the homeowners should not be able to prevent the use of the road as far as people walking along the water's edge.
Yeah, you did answer that question. So yeah, they aren't blocking us from using the road, but they were. I was just wondering how they were allowed to put a dock on it. I think you answered that they still would have riparian rights. So we
Okay.
can use it, we can maneuver it, but we can't. But they won't let you use it like walk on their dock.
Yes,
Like,
that would be consistent then with the law. I know we're at the end. I just wanted to finish this case quickly. So the point was that the bottomlands shot off at a 45-degree angle, and that's not how anyone used the lake. And we went to court, and my client, to be clear, was using the bottomlands of the neighbor, but everyone was using each other's bottomlands. Um, the what I would say is not what I would say. My argument was, well, no surveyor had gone into the water and actually surveyed the bottomlands, and therefore you couldn't establish to the court that my client was in fact trespassing on another person's bottomlands. Now, the court could take judicial notice because it was pretty clear this was happening, but my argument was, nope, you got to have a survey, and you don't have a riparian survey. And each had a surveyor, well-known surveyors, and neither performed riparian surveys. And at that point in my career, I did not know a riparian surveyor. And the court ordered a riparian survey. And what I thought was important is that I was nervous. I had a little bit of an idea what might happen, but I'd never seen it, and so I was nervous. I thought my client was going to be on the losing end. And what was important to note is that riparian surveys don't follow, or at least not intentionally, they don't follow what the platted bottomlands are. A riparian survey looks at the water's edge and the riparian lots and comes up with a drawing that's fair and equitable. And I don't want to oversimplify it because I don't think surveying's simple at all, and I definitely don't think riparian surveys are simple, but it's what logic would dictate. Now, of course, again, there's many more components to it, but we have a lot of bottomland fighting, and what's important to know is that just because the platted bottomlands may have some very odd configuration, not conducive to what logic would say, a riparian survey, which courts recognize all the time, is a way to demonstrate, and because you need one to show. I mean, you can't just say, well, logic would say that doesn't work in court. You need an expert, a surveyor. You need a surveyor that performs a riparian survey. But it can be demonstrated in court as to what's the fair and equitable use of the shoreline and the riparian rights and the bottomlands. And even if it's technically trespassing, if you will, on someone else's bottomlands, the courts will find in favor of the riparian surveyor for fair and equitable use. And it becomes a big thing in coves where people, where everyone's fighting for every inch, or bays, but even in the main body. So that's what I wanted to make sure I got out about that. I don't know if there are any more questions. I do see I'm at the witching hour, so I'm happy to answer questions. But I also understand if it's time to wrap it up, as they say.
Hey, Rick, I do see one more question here, maybe a quick one for you,
Yeah.
but it says, what is the effect on riparian rights when the original patent from the federal government covered land under the lake, yet a patent was before Michigan was a state?
Hmm. I don't think I've ever had that question. So the land patent covers bottomlands in it.
Yeah, whoever asked the question, I guess just unmute yourself here and they might be
I
able
might
to.
need someone might need to walk me along this a little bit, but I'll try to answer it.
Yeah, the land patent was 40 acres or whatever, and 20 of it is under the lake and has been under the lake. And the patent was before Michigan was a state. So I'm just wondering what that does to your bottom line. The original government survey was done in 1815 in this area, and they did not do government lots around it. So when the federal government deeded off to whatever half of the quarter, then they they got that full acreage.
So it be my opinion, it was riparian when it was platted, and it remained, or when it was created, and it's still riparian. I'm not, again, I haven't been asked this question, so I haven't researched it, but I would have no reason to believe that the fact that it wasn't a state at the time would have any bearing or influence on the ability to sustain the riparian rights, especially when in your example, or maybe your fact pattern, um, part of the land is in fact bottomlands. At that point, there is no dispute as to whether the property is riparian in nature, because the bottomlands eliminate any analysis regarding ordinary high water mark that one might have to make.
Well, it's more along are the potentially a neighbor of that able to put docks out on what would be the bottom line owned by, that was in that portion of the original.
Ah, okay, I understand now. My answer would be yes. I mean, again, it would have to be supported by a riparian survey, but the answer would be yes. There would be no ability to, well, let me go back to something I said earlier. My answer would be yes. I would need to know more facts. As I cited a while ago, it was briefly, but I said that the general presumption is that if a property abuts a body of water, it is riparian in nature. And unless there was some clear intention by document as to the bottom land and who it was for and what it was permitted to be done with it, the property that abuts the body of water, even though it doesn't own any bottomlands, is riparian and therefore is able to install a dock and moor a boat overnight. So, with that said, I'm happy to stick around. I appreciate the opportunity very much. We get to deal with surveyors a lot who help us a lot because we're not surveyors. We, as they say, we know enough to be dangerous, which means we really don't know much, but it's extremely helpful to us. In we deal with boundary disputes all the time, all over the state, mostly greater metropolitan, the 9 counties that make up greater metropolitan Detroit, but we do it all over the state, and we are very thankful for surveyors that can help us prove what we think is right. So thank you.
Well, thanks, Rick. Appreciate you. Yeah, you're doing this for us, taking time out of your day. So thanks again. I really appreciate it. So, um, if nobody has any questions, I think that's it. So, yeah, thanks again, Rick. Thanks everybody for being here. And yeah, I hope everybody has a good weekend.
Yes. Thank you, everyone. And if you think there's something else I could talk about that would be of interest, I would be more than happy to come back if you thought there was a topic that might be of interest. So thank you.
Appreciate that, Rick.
Take care,
Hey,
everyone.